Senator Banks is on his way. I had a couple questions at the end, which I will take the privilege of taking now. I ask for unanimous consent to enter several letters and studies into the record pertaining to the issues discussed today from the National Federation of Independent Business, the National Association of Wholesale Distributors, the Mercatus Center, the HR Policy Association, the National Retail Federation, the Coalition for a Democratic Workplace, and the Associated Builders and Contractors. Without objection, they're entered into the record. Next, I'll ask a couple more questions of you, Mr. Kaplan. The PRO Act and the Faster Labor Contracts Acts identify the time to first contract as a key issue. These bills seek to address this issue by mandating mediation and arbitration through the Federal Mediation and Conciliation Service, the FMCS. Do you agree with this approach? And why does the National Labor Relations Act currently not arbitration and rely instead upon voluntary agreements between unions and employers?
Thank you. I think it's inherent in the act in that the employees are choosing who is going to represent them and make the decisions for them. It is not a third party. So employees choose who represents them in these negotiations. Same thing with the employer. The employer chooses their terms. They are in the best knowledge to make decisions regarding what they can afford, what is best for the economy, and what is best for their business. FMCS, well, I would start by saying I don't know that they have the personnel that would be necessary to be able to meet these demands. But further, there's been a number of individuals who have expressed concern with putting a government in charge of determining the terms of the collective bargaining agreement, and have raised serious questions about the constitutionality of directing terms in a collective bargaining agreement, such as simple as has been talked about here, posting a notice in a workplace as possibly running afoul of the takings clause, limitations on what employees or employers can say, which is a violation of the constitutional freedom of speech, et cetera. And while I'm not an expert in constitutional law, my time on the board in a number of cases only highlighted for me the care that we should take when we start embarking on things that could potentially raise constitutional or legal concerns in those areas.
Is there any mechanism under the FLCA to give workers the opportunity to review or reject a contract that they do not want?
There is not.
Okay. Senator Markey.